Welcome, everyone. My name is Cesar Rodriguez Garavito. I'm the director of the Climate Litigation Accelerator, CLX, and the chair at the Center for Human Rights and Global Justice here at NYU School of Law. CLX is a catalyst hub for climate litigation and climate advocacy, and perhaps one of the most effective ways to accelerate and deepen the impact of climate litigation is to quickly disseminate new relevant scientific knowledge and to find ways to apply it in advocacy. In fact, this is one of the most exciting features of climate litigation. There's a greater openness to collaboration between scientists and advocates than we've seen in previous waves of human rights and social justice. This is why we needs to be an issue with the audio here. So this is why we're very pleased to host today's webinar, which will be a dialogue between new data on mental health impact of global warming on young people and the legal arguments that litigants are bringing to courts around the world to demonstrate that those and other impacts are serious human rights violations that need to be immediately addressed through more ambitious government and corporate action vis-a-vis climate change. In fact, the research on youth climate anxiety and the mental health impacts of climate change on youth is currently being deployed to support legal claims in a range of cases against governments in climate with regard to climate change. For example, in the case filed by the Portuguese youth in front of the European Court of Human Rights, the court asked the parties to address whether the youth applicants are victims of violations of the right not to be subjected to torture or ill treatment. And the applicants and their supporters are using the research on global anxiety to argue that there is indeed a violation on this prohibition on ill treatment. Similarly, and recently, in the Greenpeace Nordic Association versus Ministry of Petroleum and Energy case in Norway, now also in front of the European Court of Human Rights, youth applicants have asserted their experiences of climate anxiety to support claims of rights violation. This webinar will revolve around the discussion of a recent study, an exciting global recent study on the experience of youth around the world with climate anxiety. This survey demonstrates that the failure of political and corporate leaders to take meaningful action to stem the climate emergency is linked to high levels of psychological distress in children and young people all over the world. We will explore the psychological impacts of climate change, particularly on youth, and what these impacts mean for climate litigation and human rights law. In particular, we will address the legal avenues that may be open to climate litigators as a result of this new research on climate anxiety and the psychological harms associated with climate change. As usual, the event will be divided into two parts. The first hour will be a public panel with these three outstanding experts that I'll introduce to you as I open the panel. And then we will aim for around 40 minutes of panel discussions, followed by 10 to 15 minutes of Q&A. So those of you who have participated in previous CLX webinars know the drill, but you're free to post your questions in the Q&A chat box during the panel, and then we'll do our best to address those questions in the final segment of the public part of the webinar. And then the second part of the event will be a strategic discussion open only to the members of CLX's community of practice, where we will be thinking of ways to apply the lessons from the study in our own legal research and advocacy. With the invitation to this webinar, we circulated also information about how to become part of CLX's community of practice. For those who will be joining that second part of the event, there's a separate link that we will remind you to click on at the end of the public segment of today's webinar. Finally, because of the specific topic that we will be discussing today, I want to acknowledge the anxiety that is felt as a result of the ongoing climate emergency by those of you watching this webinar. Anxiety is not only a normal response to the climate emergency, but is also a legitimate and needed response. Anxiety can be useful when it pushes us to act, like being anxious for a job interview or an exam that can prompt us to prepare for it. However, anxiety can get so high that it overwhelms us and shuts us down. So the key question for us in thinking of our own personal experiences with climate anxiety is the line between anxiety that can motivate us to act and anxiety that can shut us down. That line is different for everyone. And in the chat box, we have provided a link to a quiz that assesses your reactor type to help find equilibrium in anxious times and a document detailing the restore plan, a strategy to cope with climate anxiety. We hope these resources can be useful for managing climate anxiety. With that, we'll open the panel, and we'll start with one of the co-authors of the study. The study was co-written by 9 specialists and funded by Avaz. And we have with us Dr. Liz Van Susteren, who's a practicing general and forensic psychiatrist and an expert on the physical and mental health effects of climate change. She has served as a clinical professor of psychiatry at Georgetown University and has been a consultant to the executive branch of the US government. As I mentioned, she was a co-author of the recent study on the impacts of climate anxiety on youth around the world and has written a book called Emotional Inflammation, which examines emotional triggers to help people find emotional equilibrium in anxious times. Welcome, Dr. Van Susteren, and thanks for being with us today. So to get us started with the basics, could you please share how you understand climate anxiety from the perspective of a psychiatrist? And also, after giving us your definition or your approximation to climate anxiety, could you please provide an overview of the study on climate anxiety that you co-authored?
I'll start by saying, welcome everyone. It's wonderful to be here with you. I know we're all kindred spirits and you're here because you sense the urgency. And I have no doubt that everyone wishes that we would be doing things more quickly. And so I will push out the statement that we're really under a timeline, we're under a gun for the actions that we need to take. So everything should be on fast forward. So I'd also like to thank Avaz. They were just a wonderful entity to work with. I've been fond of Avaz for many, many years since their inception and can't say enough about them. So what is climate anxiety? Right. Well, I would like to give off the impression that it's some real sophisticated thing that only my years of study as a medical doctor and with talking to people has enabled me to come up with something really sophisticated. But it's just what you think it is. It's anxiety about climate. And I think you said it very well, Cesar. There's a sort of window of tolerance. On the one hand, it can shut you down because you are so anxious. And in fact, I suggested that we start a group called the Climate Aware Therapists, which ended up being a directory because I was getting calls from people who were frozen with fear. Well, we don't want that because what we need is on the other end of the spectrum, people who are motivated because they run the numbers, they see what's happening, they have empathy, and they recognize the trouble that is already upon us and growing, and they take action. That's what we want. That's that Goldilocks zone where we can do and respond to what needs to be done in time. So the second question, I believe, was how did the study come about? Was that what you?
Yeah,
okay.
And the basic findings.
The basic findings. Okay, well, the basic findings are that, let's put it this way, that more than 50% of the kids surveyed, and that means 10,000 kids in 10 different countries, and it's around the world. It's not just a few European countries. Of course, it was the US, it was the UK, but it was also Australia, Brazil, Finland, Portugal, France, India, the Philippines, Nigeria. It was worldwide, 10,000 kids, and more than 50% of them feel that humanity is doomed. So, chew on that for a while. 3/4 of them have said that they fear that they're frightened of the future. I mean, how cowardly. That's what comes back and haunts me, is the sense that we would make children afraid of the future. And more than 50% say that it affects their daily lives. And about 2/3 say that they directly attribute the distress that they are feeling to inaction on the part of government. So that's your sort of 360 of the study. And I have to say, and people will identify with this, I'm sure, that many times in life you look at things and you think, oh, they should have quoted me, they should have talked to me, I thought of that, or I said that, or whatever, and you feel as if you didn't get your proper due. I have to say that I got onto this study. Sure, I did stuff for Juliana, but I have to say this was mostly the work of everybody else. And this is one time, maybe there are others too, where I got more credit than I deserve. So the credit really belongs to everybody else on this study. So there it is.
Thank you, Doctor. That's a great start. We'll come back to you definitely with further questions about the findings and also your conclusions and your takeaways from the study in your own practice and in your own work with the directory of specialists, and also with kids who are coming to you or to other specialists with situations that require some sort of psychological intervention due to climate anxiety. We'll continue the first round of interventions here with Dr. Natasha Mavro-Nicola, hope I'm getting it right, who researches and teaches on human rights, public law, and legal theory at Birmingham Law School in the UK. Before that, she served as special advisor to the United Nations Special Rapporteur on Torture, working on a number of thematic reports submitted by the rapporteur to the UN General Assembly and Human Rights Council. She's also provided expert input on human rights and ill treatment to the Council of Europe and to the Irish Parliament. So we now move to the potential legal implications of the scientific findings on climate anxiety. And I wanted to ask you a couple of initial questions. One is, what does the research on climate anxiety mean from a legal and human rights perspective? And also, if you could please explain how climate anxiety and the mental health harms associated with climate change could amount to a violation of the prohibition of torture and inhuman and degrading treatment. Thanks again for being with us today, Natasha.
Thank you so much. And I also just want to say thanks for welcoming me on this brilliant panel, and thanks everyone for being here. Solidarity on the climate anxiety front. I don't know whether I count as a young person. I don't think I do, but I have a 6-month-old baby, and I can see what is bound to happen within her lifetime in this context. So there's a lot of climate anxiety in respect of that as well. So in talking about the human rights law dimension of this issue, I will focus on the right not to be subjected to torture or to cruel, inhuman, or degrading treatment or punishment, because this is my area of expertise, but also because I think it's a very powerful, a very potent possibility in the realm of climate and human rights litigation. So the research on climate anxiety reveals, as you've already pointed out, Lisa and Cesar, that many children and young people around the world, conscious of the climate crisis and what is being done and what isn't being done about this climate crisis, are experiencing intense and sometimes debilitating emotional reactions, and many of them translate into a chronic issue. We can speak here of intense mental suffering, of feelings of fear, anguish, powerlessness, hopelessness, and also of a sense of being made to feel inferior, like you fundamentally matter less than other people. We can also speak of constant mental anxiety, prolonged uncertainty, desperation, even of the extinguishment of hope. The landmark climate anxiety study that Avaz supported shows us that these are the sorts of terms that we can convincingly use to describe what all too many children and young people are going through in the face of climate catastrophe. But crucially, these are also words that the European Court of Human Rights has used to describe the feelings that it associates with inhuman and degrading treatment in various different cases. So what the research on climate anxiety shows us is that climate change and the prospect of climate catastrophe is causing widespread distress and harm in the here and now, that many within the younger generations, even those who haven't yet been physically harmed by climate change, are experiencing severe and escalating distress because they know precisely how devastating the future looks. So here, the possibility that climate anxiety can implicate the right not to be subjected to torture or to cruel, inhuman, or degrading treatment is very significant because the right not to be subjected to such ill treatment is an absolute right. It's recognized as an absolute right, and that means that it gives rise to non-negotiable obligations on states to address the suffering that is being experienced. So recognizing climate anxiety as falling within the purview of this absolute right can be transformative in an area of law and policy where state action often appears just infinitely negotiable. I think that's why it's important to zoom in on this. And as you mentioned, Cesar, in the case of Agostinho against Portugal and others that is currently before the European Court of Human Rights, the court has actually asked of its own motion whether the right not to be subjected to torture or to inhuman or degrading treatment may be deemed to have been violated by European states, either freestanding on its own as a right, but also possibly in conjunction with the right not to be discriminated against. And therefore, we could have a very important development on this front. But the question is, can we really speak of states violating the right not to be subjected to torture or inhuman or degrading treatment? We may accept that the distress and the harm that children and young adults are experiencing in light of the findings of the climate anxiety study is substantial and severe. But the question then that we need to answer is, are they just experiencing what many lawyers might call naturally occurring suffering, or are they actually being ill-treated by state authorities? Now, we can find some support for recognizing what's going on as ill treatment and thereby as a violation of the right not to be ill treated. The European Court of Human Rights has established in its case law that somebody may be ill treated through the imposition of systemically inhuman or degrading conditions of living for which responsibility is diffuse but ultimately traceable to state acts and omissions, right? So torture and ill treatment are not only about a monstrous perpetrator inflicting physical violence on a powerless victim. It can be about inflicting inhuman or degrading conditions of living. And what we see here in the context of anthropogenic climate change is that states such as those that are being sued in Agostinho are actively pursuing policies that sustain or worsen the climate crisis and its consequences. And they're doing that notably through permitting and facilitating the release of harmful emissions. So we can say that through their laws, policies, and practices, states are subjecting the young to inhuman or degrading conditions of existence in the here and now. An additional thread of doctrine that we can find in the European Court of Human Rights indicates that an attitude of indifference or disregard by state authorities towards serious human suffering, which the authorities are aware of and also in a position to act to alleviate, can violate the right not to be ill-treated. So basically being indifferent towards human suffering that they can act to alleviate violates the right against ill treatment. And it is precisely such an attitude of disrespect that fundamentally violates human dignity, as the court often describes it. Such an attitude of disrespect and disregard, or even betrayal and abandonment that the youth surveyed in the climate anxiety study convey. They convey a sense of being betrayed and abandoned by state authorities through their actions and inactions on climate change. And in fact, what the young perceive to be the case is the case. Their feelings, as you've pointed out, are rationally grounded. They're a normal reaction to what's going on. And we can see that in report upon report that finds that through their laws and policies, states are exposing the younger generations to a potentially irreparable harm within just a few decades. So we can speak of state authorities inflicting widespread mental health harms on the young, contrary to the right against ill treatment. And to buttress this argument, for example, in Agostinho before the European Court of Human Rights, the applicants are also arguing that the wrongfulness of states' behavior is deepened by the pronounced vulnerability of children, and the fact that rather than acting in the best interest of the child, which is their duty under international human rights law, states are, on the contrary, condemning the younger generations to bear the brunt of climate change, but also to bear the brunt of the increasingly drastic mitigation measures that are going to be needed because of their dithering today. So the discriminatory character of this betrayal of the young adds to its wrongfulness and arguably should further motivate the European Court of Human Rights in Agostinho to make a finding of a violation of the right against ill treatment. I'll leave it there and I can talk about this more later.
Thank you, Natasha. That's a very helpful opening and a very direct application of the findings of the study to very real and important cases before the European Court of Human Rights. So we'll come back to that in the second round. And for now, we're going to wrap up this first round with the introduction and a couple of questions to Ruthlbert, who's a lawyer and senior legal officer at Avaaz, where she works on human rights research, campaign, and advocacy on a number of other issues, including climate change and biodiversity laws. So Ruth, after listening to our co-panelists and of course, reading the report that Avaaz funded and having internal conversations in Avaaz, which is, I couldn't agree more with Lisa about the quality and the importance of Avaaz's work throughout the years. How do you think the research that we've discussed today can be deployed strategically in climate litigation?
Hi, everyone, and thank you so much for having me. I'm really thrilled to be here with you all. So first of all, I just want to say that as a relatively young person myself, climate anxiety is a very familiar feeling for me. And that's why a lot of the work that Avaaz is doing and has done in the past related to climate litigation is so important to me. From our involvement in funding Our Children's Trust Juliana case in the US to challenging the East African oil pipeline in court, it's all part of the wider movement that Avaaz is a part of to try to save the climate and our future. And finally, climate litigation is very much a part of the momentum. So that's very exciting. And that's also exactly one of the main reasons that Avaaz funded the climate anxiety survey that then informed the study that was compiled by Lisa and many others, is because we strongly believe that it can be impactful in strategic climate litigation. The study adds to the climate anxiety narrative, in our opinion, by turning psychological harms from a sort of abstract future harm into a visceral current harm that we're inflicting on ourselves and mostly on youth. And that's why we hope that the study can play a pivotal role in the youth-led climate litigation. Some of the cases have already been mentioned here, and the Agostinho case that's currently pending before the European Court of Human Rights, and that Avaaz is also involved in by funding the applicants, is a great example of how this research could be very valuable in court cases. And for example, in the context of the European Court of Human Rights, the usual suspects, let's say, of potential violations that are considered in environmental cases include violations of the right to life and the right to private and family life. And those are obviously incredibly important considerations, but we're also really excited about expanding the list of rights that are considered in climate cases, because obviously so many, if not all of our rights, can be affected by climate change. And so this study was designed to do exactly that, provide new evidence to argue that other rights are at stake as well as we face an unprecedented crisis as a whole. As has already been mentioned, the European Court raised Article 3, so the prohibition of torture and inhuman and degrading treatment of its own accord, which is very noteworthy because Article 3 is not a commonly invoked provision at all in these types of cases, but that may change because of the court's initiative. And we hope also that this research and Natasha's well-developed human rights argument around it can play a key role in that. Because as Natasha already explained very well, the climate anxiety study indicates that children and young people are facing such high levels of anxiety and distress that it can in fact amount to a human rights violation. And importantly, the study also showed for the first time that there's a link between this distress and governmental inaction. And therefore, these findings can strengthen the argument that Natasha has developed, which is that climate anxiety and distress in youth is so severe that it violates the right not to be inhumanely treated or the right not to be degradingly treated, and that states should be held responsible for the human rights violation. So this is, in our opinion, really important new evidence that can be used in court cases around the world because it clearly shows a wider global issue and context. And importantly, as of May 2021, over 1,800 cases, either ongoing or concluded, of climate litigation have been filed in regional, domestic, and international courts. And so this climate anxiety research, we hope, can provide applicants with additional evidence and arguments, particularly in a human rights context, thus expanding the possibilities for more strategic litigation based on a wider range of human rights than we may have thought possible until very recently.
Thank you, Ruth. That is actually a great segue back into the discussion of the study. And I wanted to, and this is where, by the way, feel free to jump in, either Natasha or Ruth, as we go along. This is going to be a more of an informal exchange among the three of you or the four of us. And by the way, to those of you in the audience, in the virtual audience, this is the time for posting your questions so that we make sure to organize them into clusters and then ask them to later on to our panelists. So, yeah, you're mute.
Sorry about that. Just two things. One is that what makes this study so powerful is that the human inclination to suppress uncomfortable data is very, very powerful. And when we, ideally, we would have said to ourselves, oh, we're burning the planet down, causing extinction of the species, may make it unlivable. Maybe we should do something. That isn't happening. So what's so powerful is when you can take these numbers, put them on a piece of paper or the equivalent, and wave them in the air, it becomes very, very difficult to wave them away. The reality becomes indisputable. It is a very fixed point that is very hard for people to dismiss. So that, I want to address the issue of empathy and the issue of why this study is so important. The second thing is that I know we have called this a violation of human rights, but let me say something just a step further. Having been with children who really are experiencing and done psychological evaluation of them, this is something even more, I think, dramatic, and it doesn't go very well oftentimes in people's minds, but this is nothing short of state-sponsored child abuse. And I say that for the following reason. Abuse is not just physical abuse, it is also emotional abuse. And that includes the World Health Organization, and every child rights organization says it is also a failure to provide an environment in which a child can thrive. That's the definition of child abuse. Just because it is diluted in government and is worldwide doesn't change the fact that this is what is happening.
That's a very important addition, Liz. And actually, I want to ask you something that one hears in intergenerational dialogues or non-dialogues, because one of the major obstacles to this type of realization, being brought home to the decision makers is that there is this generational split between those making the decisions and those suffering the consequences. In Glasgow, we saw that, for example, most of the protesters were young and female, and most of the decision makers were old and male. And one response that's pretty common in journalistic and opinion circles is that the Gen Z generation has been too sheltered, right? There are books like the Coddling of the American Mind, the fact that Gen Zs are supposed to be hypersensitive because of their upbringing, and that really there's something about the way that they have been educated that makes them particularly susceptible to this type of anxiety. Of course, there are abhorrent versions of this response, like when Donald Trump tweeted about Greta Thunberg's opinions on Twitter, that she responded to very effectively later on. But I wanted to bring this up and ask for your reaction to this line of argument.
Yeah, it's called intergenerational aggression. And I'm going to put on my psychiatrist hat right now and note that about 80% of our behaviors are unconscious. It doesn't change the fact, because it's unconscious, that this is aggression. So whether it's passive, active, conscious, unconscious, the reality is that what we are doing today is specifically harming children. That is aggression. So I've said to myself, what's the cause? I mean, why would, I ask myself, and I even point out to my colleagues, if a very rich couple left their estate in disarray to their children, whom they knew were always at each other's throats, that would be an example of an aggression that might be unconscious, but it addresses the fact that the issue that might underlie some of this is, a very narcissistic injury. We are, and the word has been used so much lately, narcissism, but nonetheless, it still is a driver of decisions that we make unconsciously. So the question that I ask, is it really that we are saying, hey, I'm going to be 6 feet under while you're still walking around alive. You can deal with it. I'll let you deal with that. It was not my problem. So I think that is one driver of what is very clearly intergenerational aggression. I would love to have a few people say that the Zers are snowflakes, because I would love to unpack their aggression.
Thanks, Lisa. And finally, before we move on to the legal implications, one of the key findings that you highlighted in the previous round is the fact that anxiety is associated with government inaction. It's not just about the situation of the world. It's not just about global warming, but about the fact that young people see their governments sitting on this problem and not doing enough about it. Could you unpack that finding from a psychological point of view?
Sure. It's not just that they're sitting by. That would be one thing if they were, twiddling their thumbs and meeting for drinks after work, but they're not. They are actively supporting the fossil fuel industry. Hundreds of billions of dollars around the world are going into subsidizing fossil fuel exploration and extraction and use. So it's not just a passive participation. They're actively supporting the demise of the planet. The tax breaks that are given to fossil fuel industries, the favorable status when it comes to exploring lands and getting permits, the use of fossil fuels within government when renewable energies are available. So it's not just a passive participation. It is that there is active harm coming to children because of the actions that government is taking, not just standing by, but taking. So it's much more complicated than just, oh, well, blowing kids off. It's much worse than that. And they know it.
Mm-hmm. And finally, I can't help but ask a final question about the growing debate about the healthy aspects of anxiety and the healthy aspect of this type of reaction in a societal context. That people who are anxious and even depressed about some of these issues tend to be more realistic and more accurate in their representation of the situation than those of us who may not feel as anxious or preoccupied about basically what amount to an emergency. Is in your own practice, I know that this was not examined in the study itself, but how do you see the relationship between anxiety and climate action in terms of those feeling anxiety being more attuned to the reality of the situation and potentially playing a role in calling for the rest of us to do what's needed to address that emergency?
So let me say the following. The issue is not the focus on climate anxiety. The issue is to shed light on climate denial disorder. That's where the trouble is. It's not the climate anxiety. That is a very realistic response to real conditions. If you are not anxious, you are not listening. If you're not listening, it's because you're denying, disavowing, disconnecting, discounting, deflecting, or doing something else. So a climate anxiety is a very natural, healthy response to conditions. Again, what needs to appear in our diagnostic and statistic manual is climate denial disorder or some other disorder that relates to whatever inclination there is to downplay the dangers. So the climate anxiety, what I can say about that is that it is very uncomfortable, and it is also very useful. And I certainly have it myself, and I assume everybody else here has it. And it does sometimes make daily life problematic. For me, it certainly does. It's hard on my family. I would say that it rises to the level in me and perhaps in many others as well. And I'm not saying whether it's good, bad, or mediocre. It's not a value judgment. But what came to my mind once was as I was looking at a beautiful Caribbean beach, and I said to myself, all of a sudden, there was this feeling that it was no longer the beauty of the beach. It was dark. It was angry. There were huge waves coming in. And I realized, forget post-traumatic stress disorder. I have pre-traumatic stress condition. I won't call it a disorder because it is a reasonable response to what are unbelievably perilous conditions.
Mm-hmm. Thanks for adding that. That's so important for all of us here, and certainly for young people who will have to endure this situation for longer than many of us here in this event. Natasha, moving on to the law, one of the difficulties with dealing with the law is that, of course, it doesn't necessarily map well onto the findings of psychology or climate science because it works with structures and categories and norms that sometimes are quite rigid and outdated, right? So I wanted to ask you about how you see the law potentially being open to modifications or to creative interpretations that could help us, for example, address the fact that Lisa mentioned that some of this harm is unconscious, right? So, and the law needs kind of explicit and intentional perpetrators to allocate responsibility more clearly. Or that if everyone is affected by climate anxiety, then it becomes hard to state that a specific group, young people, are disproportionately affected by climate anxiety in ways that will give them legal standing to sue before court. So either as a reflection or as a further discussion of these issues or any other issues, could you give us some additional ideas on how to stretch the limits of the law or use the law, the existing law, to address the findings of this study and in general the issue of climate anxiety?
Thanks very much, Cesar. That is really a brilliant question, and I have to acknowledge the multiple limits or limitations of the law and indeed of the judicial imagination, right, which are quite substantial, particularly in kind of emerging areas of litigation such as this one, right? And we have to talk about the limitations of the law and of the judicial imagination when our end goal is to bring about really radical change, right, that is needed ultimately to avert climate catastrophe. So you've mentioned a couple of points that I will return to in a moment, but to mention a couple of other big limitations, sort of big picture umbrella limits. First of all, if we're talking about turning to human rights law to address this issue, we have to acknowledge that human rights law is fundamentally anthropocentric, right? It's human focused, and it won't offer us the tools to effectively protect all the world's creatures and nature itself, unless this is tied very closely to human interests and human needs. The other central limitation is, of course, as you've pointed out, that the law can be inadequate because it is made and interpreted and enforced by people, including judges, that tend to be fairly attached to the status quo. And a court that wants to shut down a climate case has plenty of formalistic rationales to do so, even before they get to the substance of the case, where they have more rationales, again, to shut down the case. So the Committee on the Rights of the Child, for example, recently rejected a complaint brought by youth in respect of the harms they're facing because of climate change. And they rejected that complaint due to the non-exhaustion of domestic remedies, which is a procedural obstacle, essentially, that has to be met for a case to go ahead. And they made this finding despite what I thought were very convincing arguments that, that children and the planet just cannot afford to waste the time that may be needed to litigate climate action and inaction in individual states and await the outcomes that may ultimately themselves be ineffective in those contexts. There were some positives in the committee's decision, but I have to say that, you know, that rejection of the case is ultimately something that has contagion potential when it comes to, for example, the Agostinho case that's currently before the European Court of Human Rights, where, as you've pointed out, the applicants don't only need to clear the requirement that they've exhausted domestic remedies, but also the requirement of standing, that they have standing to bring proceedings as victims of human rights violations, right? Now, in terms of the issue of standing, there are very good grounds to make a finding that the young applicants in Agostinho are in fact victims of human rights violations, including current violations, right? Violations that are happening to them now because they're experiencing distress in the here and now, as well as violations of their rights in terms of future harm, but that future harm is arising through current state action and inaction. And again, I think that should cement their victim status today. The fact that what they're experiencing might be ubiquitous or pervasive across the world and might be experienced by a huge number of the younger generations as well as older generations does not entail that it isn't egregious. So the fact that something happens quite often doesn't mean that it's not egregious. And to give an example that's quite distinct from what we're talking about today, the European Court of Human Rights Grand Chamber made a finding that a single slap in police custody amounted to a violation of the absolute right not to be ill-treated, even though a minority of judges on that court were arguing, well, this happens all the time, basically, and we can't possibly trivialize, as they said, this absolute right by making a deal with things that are just kind of everyday violence, right? And I think it's an important precedent, even though it's on something quite distinct, because it tells us that the fact that something is pervasive does not make it any less egregious. And the court should be prepared, therefore, to recognize a potentially wide class of victims, because precisely what we're talking about is a human rights violation on perhaps an unprecedented scale, right? Now, I was recently accused of drawing an offensive parallel between climate anxiety and the death row phenomenon. And I was struck by what Lisa was saying about child abuse, because I was accused of drawing this offensive parallel between, you know, living in the shadow of climate catastrophe and living in the shadow of execution, right, in the death row context. And in fact, that was a parallel that was drawn to me by a psychotherapist who specializes on climate anxiety. But when I was accused of being offensive in my parallel, that spoke to me of the limits of a particular kind of mindset that cannot accept that abuse can take place both in the prison cell and, as Susan Marks has told us, in plain sight and through more systemic structural forms. So if judges are of that mindset that might consider drawing such parallels or bringing these kinds of harms into the same realm as some certain forms of physical violence, if they're of that mindset that this is offensive, then they have multiple grounds to shut down the case. But what they've been invited to do in litigation such as Agostinho, and they've been invited to do that by third-party interventions as well as the applicant submissions. We've had a third-party intervention from the Council of Europe Commissioner of Human Rights, for example, that essentially tells the court to forego formalism, undue formalism in this case. And to forego it as it has foregone it in other cases as well, and to focus on the fundamentals of this case. When it comes to standing, there is clear harm that renders the applicants victims of human rights violations. When it comes to jurisdiction, we're talking about a unique kind of transboundary harm that has to be addressed by a supranational court. Otherwise, there is a vacuum essentially in human rights protection. When it comes to the need to exhaust domestic remedies, such remedies would take too long and ultimately be ineffective because they would have taken too long, even if proceedings are successful. All of these things have to be considered in order for the case, such as Agostinho, to be successful. But we've got to be conscious and have a degree of pessimism about whether that outcome will be forthcoming. And just as a last point, we've also got to be conscious that the remedial outcomes might also have their limitations as well. Although there has been a recently published piece by Helen Keller et al. That invites bodies such as the European Court of Human Rights to be a bit more creative and to look to structural and programmatic remedies that actually focus on a systematic overhaul of state policies and practices that are, as Lisa highlighted, actively creating the situation that we're facing today and worsening it.
Thanks, Natasha. That already gets us into the territory of one of the questions about remedies. So I'll come back to that in a moment, and we'll have to go through the questions very quickly. So I'm going to ask for quick reactions from those of you who feel like addressing the questions. But I wanted to finalize this round by asking Ruth about non-litigation strategies. Avance has been well known for many years for its campaigning creativity and power. So could you say a bit about the campaigning use of the survey data and in general of the findings about mental health as they can be deployed in new campaigns and for climate action?
Yes, thank you so much for that question, because we've definitely found at Avaz that people, including world leaders, are very open to hearing about young people suffering as a result of climate anxiety and climate change. And in fact, the UN Secretary General Antonio Guterres even referred to this climate anxiety study when he addressed the UN General Assembly back in September. Because in the end, these children and young people are politicians' current and future voters. And the research revealed pretty staggering data about these young constituents' views and feelings. And Lise has already brilliantly explained a lot of the findings of the study, and I just wanted to highlight a couple of additional ones that I think should be really listened to by politicians in particular. Over 60% of young people say that they're feeling anxious, afraid, and sad due to climate change. Nearly half of the global youth surveyed said that climate anxiety and distress is affecting their daily lives and functioning. 75% believe that the future is frightening. And there's a clear link with government inaction, which we've already addressed, because almost 60% of youth said that they felt betrayed by government's handling of the climate emergency, and 64% said that governments aren't doing enough. So this clearly speaks to a grave distress and a sense of hopelessness amongst youth. And when that is the message that your voters are sending you, politicians tend to listen. And so for campaigners, it's crucial to make sure that youth's voices are heard and amplified on the world stage. And that's also why it was very important to Avaz and to the others involved in the study to, for example, involve a young person in the study with lived experience of mental and other distress due to climate change. That's why it was really important when we launched the study to include youth voices on the panel, so that experts were speaking, but also the people that we were actually doing the study for and about. So we really encourage both campaigners and young people to bring this data to judges right now and in the future, but also to our leaders, to policymakers, to lawmakers across the world. And at Avaz, we have, for example, used this data to push for better commitments at Glasgow, to open the door for discussions on new regulations like the EU Green Deal, and to try to speak to politicians' hearts about what young people are feeling right now, and that much more needs to be done. And the final thing that I will say is that I was personally only a few years older than the oldest youth that we surveyed. And so their fears are my fears and their anxiety is my anxiety. And I think that fuel for campaigners, I think we all feel that type of distress that can really propel us forward to hopefully all work together to do something, because as both Lise and Natasha had spoken to, there's not that much time left and we don't have time to exhaust all domestic remedies in all countries in the world. We need to act now. And so I join Natasha in her hope that the European Court of Human Rights and other courts will also be open to that, and that politicians will also be open to hearing that.
Mm-hmm. Thanks, Ruth. And to wrap up, let's come back to the question on remedies, but let's take it from a psychological angle. So the most common remedy that litigants have asked for from courts is, of course, increased climate action, greater ambition on carbon emission reductions, and faster and more effective plans for reducing those emissions. But is there anything else that litigants should be asking for that would address the specific mental health harms that you've identified in the survey?
Lisa, you're muted.
Another excellent question. I'm going to take it from the top, and that is that in the circles in which I travel, of course, as a mental health professional, a lot of discussion centers around how do we build resilience, personal resilience? How do we build community resilience? How do we take action in a way that it helps people cope with what's going to be extremely distressing? Well, I think the medical profession generally has a problem with looking a lot at symptoms rather than causes. And I would like to see my colleagues spend as much effort going upstream and recognizing that if you're going to be drilling holes in the bottom of the boat, you can bail as fast as you want, it's still going to fill up. And I'll go right straight to the top, which is that if we would simply do one thing, and that is stop subsidizing the fossil fuel industry, which ends up creating a false low price on energy, then all of the other sources of energy, the renewable sources of energy, are so much more competitive than they already are from a cost perspective. So just removing the subsidies that we give to the fossil fuel industry would mean that renewable energy is even more attractive to everyone, corporations, city governments, state governments, individuals, the government, I mean, everyone. So that is where I look at where we need to be. Of course, we need to tend to the mental health impacts, but you're not going to convince anybody that we're going to fix the mental health stressors when we continue to cause the problem. So there you have it.
Thanks, Liz. And we have 1 minute left for Natasha to elaborate on her last idea on remedies. And thanks for sharing the link to the article. And by the way, for those of you who are part of CLX's community of practice, we encourage you to stay on or to move to the separate link that we sent you on email, because the session is going to be basically an opportunity for you to ask additional questions to this great set of panelists. So Natasha, final words of wisdom here.
I'll be very brief, but just to underline again Lisa's point that climate anxiety and state actions and inactions on climate change are a package deal, and what needs to be addressed, including in a remedial outcome in a piece of litigation or human rights litigation, has to be the cause of climate anxiety rather than the symptoms. Now, there are tools at the disposal of bodies such as the European Court of Human Rights to make demands of individual and general measures on states to address climate change and the way that they are and therefore exposing the young to current and future harm. But whether they are bold enough to take that path, I think is well, open to debate. What we should be conscious of is that the courts themselves, and notably human rights courts, are not going to solve climate change single-handedly, and rather, and this is where Avaz's campaigning work is really important, that has to be part of a wider political mobilization to change what's going on right now. We can't just leave it to the lawyers. It's a far too important thing to leave just to the lawyers, or indeed the human rights lawyers.
Thanks so much, Natasha and Ruth and Liz. And with that, we're going to bring this conversation to a close. Clearly, there's so much more to discuss, but this was a great start. And again, for those of you who are part of CLX Community of Practice, we hope to see you on the other side of the Zoom room, meaning the link that we provided separately. And for everyone else, you're welcome to join our community of practice, and a good rest of the day, evening, depending where you are, morning, depending where you are.